All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of how to draft your own will and transfer on death deed presentation. Um, Today, we would typically be doing the legal advance planning and why you need it, but we're going to do things a little bit differently today. And we'll have Miss Jessie kind of get into the explanation of all of that for you guys. But on behalf of the A Month of Service collaboration, we want to thank you all for joining us. Also included in I guess I'm Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us, we have Mrs. Cecile Carlson. Also, on behalf of our presenting partner with Lone Star Legal Aid, we have Ms. Jessie Campbell, who will be facilitating or presenting the information for you guys for this afternoon. But also included in the partnership, we have the Earl Carl Institute, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, Houston Volunteer Lawyers, the Texas Legal Services Center, and the Houston Bar Association. And collectively, we make up A Month of Service. And basically, A Month of Service is the collaboration of all of our organizations coming together on a monthly basis, offering a variety of different workshops, resources, and information to the communities that we all serve relative to asset protection, asset building, the maintaining of generational wealth, and community empowerment. We do know that there are still a lot of underserved communities out there that do not have access to a lot of information, that do not know where to go for particular resources. So we decided several years ago to come together in the hopes of creating a larger impact and reaching more people so that we can try to get as much information out to as much accurate information that we can get out to the community as we possibly can, also while empowering people to kind of take things into their own hands and to get things accomplished, to get things done that will assist with helping to maintain that generational wealth that we talk about all the time. In today's presentation, again, Ms. Jessie will be going over how to draft your own will. And again, but she'll be going over some of the other things as it relates to estate planning and why you need it. But we felt that it was important, especially because it's towards the latter part of the year, that we want people to know that they can actually do these things themselves, that it's not necessarily something that you have to spend a whole lot of money on, talking to different attorneys and things like that, that these are pretty simple form. Well, I ain't gonna say simple because, legal stuff can get a little complicated and cumbersome and whatnot. So I'm not going to say simple, but it can be done. So just know that it is possible, and we're here to assist as much as we possibly can. Also, for you guys, just to let you know that the information that does get presented here today, it is for educational purposes only. It is not to be considered legal advice. However, if you do find yourselves in need of any civil legal assistance and those as it relates to your estate planning and wills and things of that nature, that we do encourage you to reach out to our legal service partners like Lone Star Legal Aid to apply for their services. Do not automatically assume that you guys will not qualify for the services of any of our legal service partners. At the very least, please apply so that you can potentially get these documents and get other legal representation that you may need, get it done, Um, in addition to that, again, this is your opportunity to ask questions of the legal professional that we have here presenting this information for you today. However, we do want to keep in mind that we are recording this session as well as broadcasting on our social media platform live on YouTube and on Facebook. So we want to try to protect your privacy as much as we possibly can. So we ask that you keep your questions to be general, as to not divulge any personal detailed information. In addition to that, Ms. Jessie cannot answer any personal detailed information without giving you guys, without crossing the line about giving legal advice. So do keep that in mind as well. But there's a lot of information that's going to be covered here today. We hope that you all receive the information that you came to get today. We do ask that you try to pay it forward. So information that you do get, please make sure your relatives know about it. Again, the session is being recorded. We're going to send out the link of the recording, share it with your neighbors, your other relatives, and let people know that, this is something that everybody needs to get done. Nobody knows the time nor the place when you're going to end up passing or in a situation where you're incapacitated and can't care for yourself or make decisions for yourself. And you need to make sure that things are properly in place so that you don't find yourselves in a situation where things are not being able to get done because they have been planned for. So with that being said, we're going to move on to our introductions, and we're going to get right into the presentation. So thank you all again for joining us, and we're going to have Miss Cecile Carlson with the City of Houston Department of Neighborhoods.
Thank you so much, Nia. Good afternoon, everybody. Thank you so much for being here on behalf of the City of Houston. We want to welcome you and thank all our partners for being here and for this month of service collaboration. Like Nia said, this information is coming straight from the professionals, so take advantage of that. If you know anybody who might need our services or might need this information, direct them to the website, direct them to this recording, and invite them to come to our next streaming, because there's some good information here and it's a great opportunity to get some information and ask questions. So I'll pass it over to our presenter, Jesse. Thank you so much for being here.
All right. It's Jesse.
All right. Good afternoon, everyone. Thank you for the introduction. My name is Jessie Campbell. I am a supervising attorney with Lone Star Legal Aid, and I appreciate everyone taking time out to spend some time with us today to learn about how to draft your own will and transfer on death deed. A little bit more about Lone Star Legal Aid. We are a civil legal aid program, so we provide legal services on a variety of different types of topics that you can see here on the slide: consumer, employment, family, housing, estate planning, and probate, just to name a few of the things that we do. The things that we do not handle are like criminal, driver's tickets, personal injury, and those are the types of things that we do not handle. But overall, if it's a general kind of thing that people encounter with the law, we can probably assist. We serve 76 counties, 72 in the state of Texas, the eastern third of the state of Texas, as far up as well as 4 counties in Arkansas. So our region covers from Texarkana all the way down to Galveston, and as far west as Waco and Belton is where we are. We do have our headquarters here in Houston, Texas, which is where I am located, as well as 13 other branch offices throughout that service area that we provide. So if you know anybody who may need assistance in this particular area of the state, just know that we are available and able to assist. We are free, but we are based on eligibility. So individuals must apply for services, and that eligibility is based on income and assets for the size of your household. It is a pretty complicated mathematical, process that we go through, but it is, so it's hard to say for sure who or who not will not qualify for services, but estimates have been as high as 40% of the state of Texas qualifies for services. It's probably more accurate at this point in time for it to be around 30 or 35%. So you may actually qualify, so don't assume that you don't. Okay. As Ms. Nia says, today's presentation is for educational purposes only. I cannot provide any advice on any individual situation today, so please be aware of that. And also, this doesn't replace legal advice. You shouldn't take anything I say today as being the end-all be-all of the aspect of this area of the law. For your own individual situation, if you are able to do so, we do recommend that you go seek an attorney to be able to answer those specific questions. All right, so today for our agenda, we're going to be talking about some pretty high level kind of things. So we're going to be talking about how to choose your representative as we decide on going into drafting the documents. And then we're going to talk most of the time, over an hour, we're going to spend going through the will form that we're going to discuss today on how to draft it. Like literally line by line what needs to be included in those in those paragraphs. And then we'll cover a transfer on death deed at the end. And then very briefly, we'll talk about how to get the documents needed planning for incapacity. What we will not be talking about today is a general introduction to legal advanced planning, the entirety of what it is, why is it important, the types of problems that you're trying to avoid when you are doing advanced planning and what you need to know, the difference between estate planning and probate. All of that is covered in another session that I do, which we did in October. And that video is available for your viewing at our YouTube channel for a month of service, which you can see here on our screen. If you have registered for this session, Miss Nia will send you an email afterwards linking this recording as well as to the other channel's videos that you'll be able to see from connecting from this video. So go check it out. It also has all of our other topics that are there that you can check out, including probate. We will not be talking about probate. Probate is the process of what happens when a person passes away, or title clearing when you need to do something when you've inherited property and you didn't go through a probate process. What do you need to do to be able to clear that title? We will not be covering any of that today as well. So if you have questions around that, we do recommend that you come to our other program, which will be later this month. Please check the calendar for the exact date and time for that session, or you can also go watch a recording if you're not able to attend, but go ahead and register for that event. Okay. All right, so let's talk about choosing your representative. When we're talking about a will, what we are talking about is your executor. That's the name of the role. And the executor is a person that's going to be stepping in, that's acting on your behalf when you're not able to do so. And that's what it is when we talk about representatives. And so the executor is going to be handling the probate process. That's going to be their job. And it's a job. There's actually quite a bit of work associated with doing a probate, depending on the estate and what needs to be done. But an executor is the person who will work with the attorney to go through the probate process. They will identify the assets and they will pay debt that they need to pay, contact creditors, explain if debt cannot be paid, kind of manage all of those aspects. And then when they're talking about managing the estate, it will also include distributing the property. So if the will has instructions on selling the property, the executor is going to sell the property and then make sure that the proceeds are divided equally or according to the instructions in the will. If the house is being inherited, if it's being transferred to a person, the executor is going to be drafting the deed that will transfer the title of the house to the heir. So it's effectively a job to kind of handle this work. And on average, it will take between 9 months to a year to complete. But a probate can take longer than that. Some probates can take years to complete because again, this is work. This is things that take time to do and you have to navigate that. And some can take 2 to 4 years to complete. Usually most probates are done within 4 years. Some will take less time, depending again on what's going on in the estate. And so we're not going to know how to tell you what to expect without knowing what's in your will and what kind of estate we're going to be dealing with. But just be aware that when you're selecting a person, that's what you are asking them to do, is to kind of do that work. So when you think about that, the person you should be choosing is someone you know and trust who will do what is in your best interest or as you would have done in the situation. Effectively, when it comes to a will, are they going to follow your instructions? Do they understand your instructions? Do what you've asked them to do in the best interest of the heirs, of the beneficiaries of the will, and making sure that it's done correctly and that the estate is preserved as best as it can for the heirs. You do want to pick one person to be in the role, as well as an alternate. We always recommend one person because one of the reasons why we draft these documents is to avoid conflict. We want to be sure that the instructions are clear and everything is able to move forward and that, there's no arguments about whether we should repair the house before we sell it versus selling the house as is. All of that role and in decision making will be vested in the executor. And so we do recommend that you do not pick shared authority for that reason. To kind of think about it as, do you really want two people driving a car? Because that's what it is. It's someone driving a car when it comes to managing the estate. You're going to want to explain the decisions that you made so that way, again, that your executor understands what it is that you meant by the terms and the language and what property that you meant. You will see as we talk about things that I'm going to tell you to be as clear as possible, be precise in language, so that way there is very little interpretation that needs to be made, but you still are going to want to have those conversations with them. And then, of course, as I said, you're going to need an alternate in the event that your first choice is unable to serve for any reason, whether through their own passing, unavailability due to moving, or incapacity, illness, or just unable to take on the responsibility at that time. You want to have a person that can step into that role, and you're going to want to have the same types of conversations with that person as well. So we're going to now start talking about how to draft a last will and testament. So one of the things that you first need to know is, what does a will cover? A will doesn't cover everything. A will only covers what are known as probate assets. And so the best way to think about it is that a will covers anything that isn't a non-probate asset. It's kind of a double negative there. But a non-probate assets for most people are these four types of property. They are owned in such a way that our state legislature over in Austin has said, hey, this property, when you have the names of a beneficiary named, they don't have to go through the probate process. And so those are going to be retirement accounts, your IRAs, your 401ks. You're going to designate a beneficiary with your financial institution where those accounts are held. For your life insurance proceeds, again, you're going to designate a beneficiary for that. And for your banking accounts, your savings and checking accounts, you can make those into payable on death accounts. So where, again, you're designating a beneficiary. Now, for those three types of properties where you designate a beneficiary, what will basically happen is that the heirs or the executor, but more likely the heir, will contact that financial institution and inform of the passing of the individual who held the account. Financial institution is going to say, okay, sorry for your loss. Here is the form that we need you to complete. They will likely ask for a certified copy of a death certificate, and that will get submitted and handled directly with the financial institution, and then whatever their procedures are to transfer the property, either opening up a new account or writing a check or wire transfer or something along that lines, is what they will do in those situations. And so pretty straightforward. There's the other type of property that can pass outside of probate is going to be a joint tenancy with a right of survivorship. These are going to be people who own property together, but typically in Texas, just to explain this, typically in Texas, when you own property together with somebody, the survivor, the other owner, doesn't automatically get the property. That's not how it works in Texas. Your property goes to the heir, which may or may not be your co-owner. It depends on your situation, but it goes to the heir of the individual, and it's their portion of the property that is owned. So, for example, if you are married and you are co-owners of a banking account, and a person passes away, their heir may be their spouse, but if they have children from a previous relationship, the children will be the heir of the property, not the spouse. So that's just a quick example of a situation where the co-owner will not be the heir, because it just depends on the family dynamics and how the family is set up on who inherits the property. So it is possible to create property as a joint tenancy with a right of survivorship, where in that situation, the co-owner will automatically get the property. So you have spouses, they're joint owners, joint tenants with a right of survivorship. The fighting spouse is going to automatically own the property, even though under regular Texas law, the children from the previous relationship would normally be considered the heirs of the property. Usually, I generally recommend that you do talk to somebody before you convert property to joint tenancy when a right of survivorship. You do have to create it. It's not something that automatically happens. Just to be sure that you are protecting the interests of any heirs that would not be your co-owner in that particular case. But that is a way of having property be did not have to go through the probate process. But that's it. Otherwise, everything else is considered a probate asset. Now, we're going to talk about a transfer on death deed at the very end, and that is a way to bypass the probate process. But a house is considered a probate asset. So if the transfer on death deed did not exist, the house would be covered under your will, as well as your bank accounts, your cars, your furniture. All of that is what's going to be under your probate assets. Now, for your non-probate assets, these accounts, your 401k, your life insurance policy, etc., if you don't have a beneficiary named on it, it's silent, you never updated it, and you didn't put in a name, then that will become a probate asset because now the estate is the owner of that money, and so now it's going to get put into the estate, and then it will pass according to the will that is written. Okay, so one of the things that when you are doing your own drafting and you're thinking about drafting your own document, it's really important to remember your non-probate assets. Be sure that those are up to date. You want to make sure that you have beneficiaries listed, that it's doing exactly what you want. Because they don't go into the probate process, there's no way to challenge that. So if you have a life insurance policy that's going to an ex-spouse and you didn't update that, your ex-spouse is getting your life insurance policy. So just be sure that you're also double checking that as part of your own when you're doing your own advanced planning documents. All right, so types of wills. We're going to be talking about a form today, but it's really important that if you are drafting your own documents, that if you're doing one or the other, that you understand that there is a difference and that there's different requirements for it. In Texas, you can do a will 100% in your own handwriting. That's called a holographic will, but it's basically a handwritten will. It does need to be in your own handwriting. That cannot be delegated. You cannot be sitting on the couch and ask your child to write it out for you. That is not in their own handwriting. That is not considered a valid will in Texas. It has to be in your own handwriting. In order for it to be valid, you need to sign and date it. But that is it. That's all the requirements needed for a handwritten will. Is 100% in your own handwriting, signed and dated. It is optional and highly recommended to have two witnesses over the age of 14 who are disinterested. Disinterested means that they don't benefit. They don't owe you money. You don't owe them money. They're not related to you by blood, marriage, or adoption. There's no reason for them to have they're going to gain nothing and they have no interest in what the will says. And so that's going to be what is considered a disinterested witness. So highly recommended for your handwritten will that you do have witnesses if they are available, as well as to use a self-proving affidavit, which is also an optional thing. And I'll talk about self-proving affidavit in a second. The other type of will is an attested will. This one is 100% typed, where you're going to take out your computer or your typewriter if you're so inclined. You're going to clickety clack, it's going to print out, and now you're going to have a typed will. And that will is for that to be valid, is also signed and dated, must have two disinterested witnesses over the age of 14 witnessing that. And basically that execution process looks like you're all sitting in a room in a triangle, we're all watching each other, and you're going to sign and date their will. They're going to understand you're signing. You're going to say, I'm signing and dating my will. I need y'all to watch me sign and date my will. And they're going to be like, cool, we got you. And then you're going to watch each other. Witnesses are going to watch each other sign. And then everyone is just in a one big happy room kind of doing that. So that is what is required. That is required for a typed will for that will to be valid. And now that one you can delegate. You can ask someone else to type that out for you and that type of thing. And so what is optional for a typed will is a self-proving affidavit. So a self-proving affidavit is optional. But why is it really useful to have when you're doing that? And it makes the probate process easier. So a self-proving affidavit is an affidavit that is signed by you, the testator, the person writing the will, your two witnesses, and the notary is watching this happen. So that everyone's watching each other sign everything. The notary is also watching everybody watch and sign everything. They're going to notarize it. And so now what's going to happen is what happens in court. When you go to court, the judge is going to say, all right, I am ready to see the will. Your Honor, here's the will. If it is witnessed, they're going to ask the one witness to come to court to testify. Yeah, Your Honor, I was there. I saw Jessie sign her will. She was of sound mind. Everything is great, right? And they're like, okay, that's good. Let's go ahead and do that. Well, sometimes witnesses are hard to find. You aren't able to find them. And so, which is why you want two, so that way even one, right? Because you need one that, but even then, two can be hard to find. They move away, there's a falling out, they pass away. So what happens in those situations is that the self-proving affidavit is where that is really helpful, because now what will happen is you'll go into court and you'll say, here's Your Honor, here's a self-proved will. The judge is going to be like, all right, let me take a look at that. And it's like, okay, there's the signatures of the witnesses. Everything is, the form is all correct. There's the notary signed in there. Fantastic. No witnesses required. So if you are able to do it, we do recommend that you utilize a self-proving affidavit with both your holographic will or your attested will, because it does make that probate process easier. The will that I'm going to talk about in a minute is a self-proved will. So when you complete this according to its instructions, at the end of it, it will be a self-proved will. Excuse me. I cough when I am thirsty, so apologies for that. Now, in the state of Texas, the law is really clear that the will must be either 100% in your own handwriting or 100% typed. That is what the law says. It's absolutely clear on that. And so so there's no such thing as a hybrid will, no fill in the blank wills. That is what the law has been for a long time. I am about to talk about an exception, which is going to be this forms I'm going to tell you. Now, in my personal opinion, me as an attorney of having this opinion, when you use these forms that I'm going to talk about with the Supreme Court forms, my recommendation is to do it on a computer, to type it out in the computer and print it so that it is 100% attested will. It is an attested will, 100% typed, because that follows the law 100% accurately. So just kind of keep that in mind, because this is going to be a fill in the blank will that I'm about to show you. But the Supreme Court of Texas, which is the one who drafted these forms, have said that it is okay for these forms to be fill in the blank, that you can complete these forms by hand, where half of it is typed and part of it is written, is in handwriting. So, but I will tell you that this is the only time that I will say that if you must do a fill in the blank will, use the Supreme Court forms. It's because the law is clear. Has to be 100% handwritten or 100% typed. So this is an exception that has not been made for other types of fill in the blank will. So hopefully all of that is clear. And but again, just recommended, make sure that you can do it on the computer so you can print it out. So what are these forms? There are the Texas Supreme Court forms. They are approved. That is the link. Don't worry about writing everything down. You will get an email with the information in it. And of course, you can watch this recording at a later time, where they have created these fill in the blank wills that are simple wills. There's 4 types. Person who is single, widowed, or divorced who has children, a married person who has children, and then the same when you do not have children, a single person, widowed or divorced, who does not have children, and a married person who does not have children. And so these are the forms that are available. They are also available in Spanish, but they're Duolingo. So they're going to be in English and in Spanish, because legally the will has to be in English. Right. So here's the question. Can I use this form? This is where it's testator beware. Testator is the person who's writing the will, right? Be really cautious about this. Because I get asked, can I use these forms, Jessie? Sure, you can. Of course you can. But the thing is that when it comes to drafting your will, It's an individual plan. It's an individual need. What do you need to accomplish in the transfer of your property and handling of your debt, and what needs to happen with that? And there's a lot of factors that can come into an individual plan. Your family members and your dynamics. Maybe you need to disinherit somebody. That's not going to be in this template. The type of property that is owned. That could, sometimes the property ownership is complicated, and the type of, and whether or not it's going to impact what we want to do. Who's inheriting it? Do they have special needs to take into account? So we're thinking about people who are living with disabilities and receiving government benefits. Having an inheritance can have an impact on their government benefits. And these forms that I'm going to show you today don't take that into consideration. Is there someone who's living under a guardianship? Is the person inheriting the property incapacitated, where someone needs to be managing their property? Are there minors inheriting the property? And how does that, and depending on that situation involving the minors, do we have to take into account certain considerations for that? The debt owed. If there's debt owed, we may need to put some different types of instructions into the will to ensure that the debt is handled the way that you want that debt to be handled, going forward. And we have to take into account mortgages, reverse mortgages, and car loans, particularly, because those items have to continue to be paid. If they are not paid, then they will be foreclosed on. And with a reverse mortgage, an important thing to remember about that is those are due 6 months after the person passes away. And so you got to take that into account in your own advanced planning on how do you ensure that if we're trying to protect the home for the next generation, for the heir, that how do we get that reverse mortgage taken care of and paid for? And so, and then there's special instructions. Are there special instructions? And there's a variety of things that I have seen. The most common ones are things known as life estates. There's someone living in the property. So someone is a child has moved into the home to help care for an aging parent, and it's like, oh, well, they've moved in, and it's multi-generational, and there's now grandchildren living in the home, and they're going to school. And so parents like, hey, I really want my child who's living with me and helping me take care of things to be able to stay in the house as long as they want, but at minimum, at least until my grandkids finish school, so that way they don't have to change school systems and things along that lines. That's a life estate. That's an instruction. Other types of instructions are, hey, Susie helped me replace my roof 10 years ago. And, she deserves to get some of that money back. I mean, she took money out of her own savings, and, it's not right that she doesn't get that money back. And so when you sell the house, I want the first $10,000 of that sale proceeds to go to Susie. And then the remainder is divided among my 3 children. Those are special instructions. And again, the form I'm going to show you is a simple will, very straightforward, very basic. And if it doesn't meet your needs, then you should be consulting an attorney or thinking about drafting your documents in a different way. So just kind of be aware of that. So that these forms are good forms if they accomplish what you want to accomplish with your estate. But if they don't accomplish it, then you should use you should go find a different source of your template, or hire an attorney, or apply for services with a legal aid provider if you may be eligible for services. So just keep that in mind as we move forward. All right. Okay, now we're going to go into the individual sections. Do not worry about, remember, this is recorded. You can come back where you can stop and pause and follow along as you go. And I know that some of this may be hard to read. I am going to be using one set of forms, and then where they are different from married versus single, I will let you know when they are different. All right, so the first section is going to be the same for everybody, which is identifying yourself, right? So you're going to put in your full name. You're going to put any names that you may be known as, nicknames, aliases. My dad had a nickname for his entire life that he never went by, that he hated, but his family always called him that. He also had a legal name change, and he had also, in his will, it included his name prior to his legal name change. So you want to include things like that, so to help identify yourself. The second sentence is a basic legal language sentence, which is that you're declaring that it is your will, that you revoke and cancel any wills before this one that you are now signing. And you will automatically revokes a previous will, but this is just making it really clear. You will find that a lot of times language is included because lawyers are just being assured that we're dotting some I's and crossing some T's to make sure that everything works the way it's supposed to work. Um, and you're going to name a spouse. So again, remember, these are going to be different depending on the form that you're using, but this is the the married document. If you're not married, that sentence is not in there. You're not going to have a spouse there. You're going to say that who you're married to at that point in time, and then you're going to have a section talking about your children. And I didn't put a picture of that in there, but it's just basically a table. It's a chart where you're going to name a child with their date of birth or date of death if applicable. And that is pretty much it on the first section. Pretty self-explanatory. Okay. And you can see, by the way, when I talk about that exception for a hybrid will, a fill in the blank will, the very beginning of this will, you can see where it says type or clearly write the information in here, right? Fill in the blanks and boxes below on the computer or by hand. But again, this is the only fill in the blank form that I am going to recommend that you use, has a fill in the blank form where it's both in handwriting and typed. But my recommendation is to type it if you can. Right? The next section is section 2, which is the everything I own section. This is a catch-all, right? So this is, you're like, you know what? I want everything to go to my spouse. I want everything to go to my children equally. That's what this section is. This is not where you're going to list grandma's diamond ring. My favorite cardigan. That's not what's coming here. What's here is everything I own. And then you have kind of two options. Oh, by the way, and everything you own is your separate property. And if you are married, your half of community property. Community property is owned 50-50. And so you're only conveying the part of the property that you own. And so, but if you're single, then everything is everything you own. You don't have community property because you're not married. And so the option 1 is what this section is, which is you're going to give everything to your spouse. And if your spouse does not survive you, to be equally divided among your children. And that is what that section 1 is. So it's pretty straightforward. By the way, I'm going to let you know, this is the most common thing. Most people, this is what they want in their wills. And so this will accomplish that purpose. Now we have section 2, well, or option 2. Now, option 2 is to bypass your spouse. So you have children from a previous relationship, or even if they are the children of your current spouse, sometimes people want to go ahead and just move on over to their, it's like, this is actually pretty common when when it's an elderly couple writing their will, right? So they are in their 80s and 90s and they are writing their will and they're like, there's no point going through a probate process to give everything to my surviving spouse. Let's go ahead and get everything to our children right away, right? It's also a thing where it's children from a previous relationship. Where do you want your property to go to the children as opposed to your current spouse? And so that's what this is that even if my spouse survives me, I give everything in equal share to my children who survive me. So your spouse receives nothing under option 2. Okay. And then so for our single person, our person who's currently not married, this is where you can put down everything you own but you're going to list your each person that's going to be getting it if you do not have children. So this would be the named individuals, and it will be equal. It will be divided equally. So if you put in 2 people, they're going to get 50%. You put in 3 people, they're each going to get a third. And so again, this is intended to be simple. It's not supposed to have those instructions in there, right? As you can see that none of those instructions I talked about, like life estates or first portions of property or anything along that lines, goes into that. Now, for all of this, if the person that's inheriting the property also includes the home, then you're going to skip the next section. But if you're going to give your home in a different way than this catch-all phrase, then you're going to complete the next section, which is about a specific gift involving your house. The one option is each person named gets an equal share. And remember what I mentioned earlier, all property is inherited subject to debt. And so this includes mortgages and liens. Whoever is inheriting the property will need to be able to continue making those payments, obtain their own financing, or completely pay off that debt in order for them to inherit the home and be able to keep the home. Right. We are going to be talking about a transfer on death deed in at the end of this presentation. And just be aware that a transfer on death deed supersedes a will always. And so if you have a transfer on death deed that gives your property to Bob, and then you write a will giving your property to Susie, Bob's going to get the house. You write a will giving your house to Susie, and then you write a transfer on death deed giving the house to Bob. Bob gets the house. It doesn't matter. The transfer on death deed always takes precedence over a will. So just be aware of that. So if you do have a transfer on death deed in place, you will skip this section as it relates to the house. The next part of the specific gifts is around personal and household items. And so you're going to name the specific item and list the individual person here. Okay. So I'm sorry. This is not the specific item. This is household and personal items. So this is where you're not saying grandma's ring, right? This is not where you're saying my favorite cardigan. This is my personal property, right? So all my furniture, everything I own is going to go to these individuals, but I want the personal property to go to these individuals, as opposed to everything else. So I'm going to kind of repeat things a little bit so that everyone is kind of on the same page. So we have our general section, right? Our section 2, everything goes to one person. That's everything. So, right, like, so if you complete that section and that section only, then your house, your car, your furniture, clothing, except everything will go to those individuals listed equally, or to your spouse, or however it is that's set up. However you write that out, that's how it's written. But if you complete section 3, which is this section, you're going to say, okay, so my house is going to go to Bob, right? So you've put that your house is going to go Bob, but your first section says everything divided equally between Bob and Susie. So Bob gets the house, and then Bob and Susie split equally everything else, the bank account, the furniture, etc. Right? So you skip the house section and you go to the household effects and personal items, and you say everything here is to Bob. Well, then Bob gets all of that. He gets the house, the bank, he gets the furniture, the clothing, all of that stuff. And then the house that you skipped, right? You skipped the section on the house, goes to Bob and Susie equally, because that's what you wrote in the general section. So I know this can be a little confusing. So just know that that's how these are working together. Okay. And then just so that you're aware, the way that this is written is that if anyone should disagree on the splitting of the personal properties, the executor is the final decision maker. Remember, we're trying to avoid conflict going forward, and the executor will serve as that tiebreaker on who gets what if there is conflict. But otherwise, each person listed is sharing it equally. Bob and Susie, 50% each. Okay. Now we get to the specific items. This is where you're going to list grandma's diamond ring, my favorite cardigan. You want to be sure that it's absolutely clear when you're writing the description. If there's 2 grandma's diamond rings, which diamond ring is going to Bob, which diamond ring is going to Susie, right? You're going to describe it specifically in a way that your executor knows exactly what you're talking about when they are going to be working through the will and distributing the property. Be careful of anything involving locations. Don't say, grandma's ring that's located in my dresser drawer well, which dresser drawer? Where is it going? Because what happens if you move it? What if you put that ring in not your dresser drawer, but in your desk drawer? And now you have, right? So be careful of things like that. You don't want to describe things based on things that can easily change. You want it to be a precise description of the property itself. And then you're going to list the full name of the person getting the information. If people have similar names or same names, then you're going to want to be sure that you clearly identify who you were talking about. There is a joke in my family where everybody's name is James and John. Like everybody's name is James and John. You walk into a room and you yell at James, half the room turns around. You yell at John, the other half turns around. So lots of similar names, and that's pretty common in families. Families have family names, and so you're going to want to be sure that you write that down, right? You're going to be like John Jacob Smith, you know, Bob's son, right? As opposed to John Jacob Smith, Susie's son, right? So if you have people who have similar names, you're going to want to be sure you identify the relationship or more details so that they know which person you were talking about. And again, that if there's anything where there is some lack of clarity and there's some arguments and things along that lines, the executor is going to serve as a decision maker in those disagreements of where the property will go, which is why it's really important to kind of circle back to that beginning where I talk about choosing your representative, that you have these conversations with your executor so they know exactly what you're talking about, right? Hey, when I say my favorite cardigan, I mean, the blue and green one that I've had for 50 years that you see me wear every single Sunday. Like it's not the other cardigan that I wear. So it's when I talk about grandma's rings, this one, the one that I'm talking about here, is the diamond cut or the emerald cut that grandma got from great grandpa and this is the one that, and the other diamond ring is the one she bought herself on her 50th, anniversary. Like, right. Like, so to the point where the executor is able to step in and do what they need to do and identify that work. Okay. So the next section after that is going to be naming the independent executor. So the requirements for a person to handle the estate is that they must be 18 years old and the court must approve them. And typically the court will approve them unless they are not able to serve for some reason. And there are reasons, right? It used to be that a person with a felony was unable to serve as an executor. That has now changed. The law recently changed, went into effect this year, where a person with a felony can serve under certain circumstances. They have to be bondable. They have to, so there's reasons, but for the most part, most people named as the service executor are able to serve as the executor. This is identifying the person to serve as an independent executor. So what does that mean? It means very little court oversight. That's what it means. So going back to that probate process a little bit, we've gone to the judge. We're like, here, judge, here's a will that's been properly executed. It's been self-proof, so no witnesses are required. All right, judge is going to read the will. It's going to say, okay, it's an independent executor. Fantastic. We're going to go ahead and issue letters so that way they can go do things. And now go forth and do what you need to do. Go write those deeds that you need to write. Go talk to the creditors. Go sell the house. You don't need to come back to the court, except for a couple of requirements, but it's not even coming back to court, it's filing documents. But now you don't have to talk to the court about any of that. And so that's what makes this is what makes the probate process easy in Texas. The independent executor. So they are able to do things without court oversight. If they're not an independent executor, if they are a dependent executor, the court will have to provide permission to sell the house, to transfer the deed. They're going to take a look at everything before the executor is able to do what they want to do. But once this is in place, that probate process that people are scared of is what makes it a lot easier and much more cost effective, less, so in general. So this is the important part of a will. One of the important parts of a will. You're going to name your first choice, a second choice, and a third choice. And those conversations that you had with your first choice executor about grandma's ring is going to be the same for second choice and third choice. Okay. After that, there's language in the will that's going to talk about the independent executor and what they're allowed to do. So the first one is that they're going to serve without bond. A bond is basically an insurance policy, right? It's protecting the estate against any mismanagement. There's an expense associated with it. You have to buy the bond. That can be it can be expensive depending on what the estate has, and so this is a way to avoid an unnecessary expense because you've chosen someone you trust, someone that's going to do exactly what you've asked them to do. So there's no reason to worry about having a bond. So they're going to serve without a bond. And then the second paragraph, the next one, the 4.3, is basically saying that the executor can handle the payment of debts and sell property to pay debt if they need to. So basically, the executor has been given, this is the power for the executor to do what they need to be able to do. And then the next one, which is 4.4, is that the court is not going to be involved. That independent part, right? They're not going to be part of making the decisions. They're not going to be doing anything except for the things that they are required to do by law that they cannot not do, right? Which is going to be recording the will, providing notice to the beneficiaries. There is a required document known as the inventory, appraisement, and list of claims that's due within 9 months of filing the probate. And that they cannot abdicate their responsibility for because the law says they cannot. And so those are the things that the court will do, making it, again, that independent administration. So now this is going to be for people who have children and who are going to be inheriting under the will, right? So minors generally cannot own property on their own. There's exceptions and things like that, but generally they have to have their property held in trust in some way or another. For them to before they are able to inherit it. And so this next section for the wills, and this is the same if it's married or unmarried. If you have children, the sections are the same in both documents, which is who's going to be taking care of the gifts, the property that the children will be inheriting under the will. And so it's pretty standard language in general. So 5.1 is saying that anyone under the age of 21 is going to require a custodian to take care of their property following what is known as the Uniform Transfers to Minors Act of Texas. It's just the name of the law. The executor may name the custodian for any beneficiary under the age of 21. So the executor can name somebody else. It doesn't have to be the executor, but the executor can also name themselves. We'll consider appointing a beneficiary surviving parent as the custodian, but it's not required to do so. Surviving spouse, surviving parent. They can name different custodians for different beneficiaries. So there's 3 children. They can each have different custodians. And then of course, then the executor may serve as a custodian. So this is basically creating the powers of the executor to transfer the property and name the custodian of that property in the event that the person inheriting it is under the age of 21. Okay. And then if you have children under the age of 21, or if you are the guardian of an incapacitated adult child, so you are the guardian, you need to name a person to take care of them until they are of age, if they are a minor, or until the incapacitated need for the guardianship no longer is required for the incapacitated adult child. And so that is going to be the person that you name here. Right? And so you're going to name a first choice and a second choice, and the guardian must be approved by the court. And there are certain rules about that as well, similar to who can serve as the executor. And so that is where we're taking care of people who we are in charge of caring for ourselves. All right. Then the next section is basically saying that Texas law applies. The standard survivorship clause is 30 days. And so what does that mean is that a person has to survive for 30 days before they're allowed to inherit under the will. This is to kind of avoid complex multiple probates at the same time. Unfortunately, accidents happen where more than one person in the same family may be impacted, and so they're like in a car accident together. And so this is to try to avoid those complicated probates. So the standard language is they have to survive 30 days, and then on day 31, that's when they're going to be eligible to inherit under the property under the will. If they don't survive, if they were in that car accident together and they pass 15 days afterwards and it's less than that 30 days, then instead of it passing according to the will of the person, the heir, it's going to go to the alternate. So, right. So remember, section 2, you said everything to Bob. In the alternate, it's going to go to Susie. If Bob doesn't survive the 30 days, then everything will go automatically to Susie rather than passing to via Bob's will. Is basically what the survivorship clause is putting into effect there. And then, of course, it's just saying that Texas law applies. Now we're going to do the execution, attestation, and the self-proving of the will. And so again, the witnesses requirements are 2 witnesses over the age of 14, disinterested, and not receiving or otherwise benefit under the will. So just a reminder of that. You're going to write the name of the testator. That's you, the person writing the will is the testator. Your name of the first witness, the name of the second witness. So that's what you're doing in this section here. All right. And then with the notary present, so this is where the self-proving is kind of coming into play, right? This is going to be all done at the same time. So remember, we're all watching each other, our little triangle of people. We have our testator, our person signing our will, our 2 disinterested witnesses over the age of 14, and our notary sitting at a table, and we're all watching each other sign the will. Right? And so that's basically what it's going to be. But this section on section 8 is basically saying that they're the testator, that it's their will, they're making this will of their own free will and deed. They're signing it in front of the witnesses. They have requested the witnesses to be there, and that they are now signing it. Then you're going to sign and date it, the requirements of the sign and the date to make a will valid in the state of Texas. And so that is what is happening here. And then what you don't see on this is that the next page has the signature blocks for the witnesses, as well as the signature block for the notary to affix their stamp. Now, the notary is the one that will finish the process after this stage. They will go through a questionnaire that's written on the page. They would just basically hand it over, and they'll just basically go through this process. Now, one of the things that's really important to know, not all notaries will execute a will. So it's pretty unlikely that you're going to be able to go down to your local UPS store, use that notary down there to be able to do it. Not all banks will do it either. Some people think they can make an appointment with their bank and their bank will do it. It depends. It depends on the individual bank on whether or not they will have a notary there that's willing to notarize a will. But don't worry. We do, as part of the month of service partnership, our partners at NRCDC actually does have an opportunity once a month to be able to help you execute with a notary the wills that you draft yourselves. So there are options available to you in the event that you are unable to find a notary that's willing to do the will with you. All right. So that's it. That's pretty much the process of writing the will. It's pretty self-explanatory. Like, it's not a difficult process in general. But as you can see, I'm going to go back so that way you don't start reading something. But as you can see, kind of going through it, it is simple. Everything to Bob and Susie, except for house, except for household items and personal products, except for grandma's diamond ring, right? Like, and anybody listed, if there's more than one person, equal, 100% divided equally. 2, 50%, 3, a third, 4, 25%. That's how it's all written down. You will see, as I talked about that individual plan, just going back to the individual one, there was no special instructions as it relates to first $10,000 of the sales of the proceed, instructing them to sell the house versus not selling the house. There's no specific instructions as it relates to debt, like how to make sure that debt gets paid. I want to be sure that, like, that whatever assets are available goes towards paying the reverse mortgage, before requiring the family to do anything. So all of that kind of, there's nothing in there about the person inheriting the property that potentially is receiving government benefits because they're living with a disability that we need to protect for. So remember, this is a simple will. Don't forget those individual needs. And if you're unsure, please consult an attorney, because the last thing you want to do is to put a will into place that doesn't do what you needed to do, creating other problems that can't be fixed. The best solution to a problem is to prevent the problem from happening. And so, if you have those seeds are in your mind about what to do, go consult an attorney. I'm trying not to sneeze. I'm really sorry. All right. Okay, so now what do you do next? So now you have the will, it's done. You're going to staple it. So the notary will probably do it for you, right? The notary will probably staple it, but you're going to staple the will. And now what's going to happen is you are never ever going to unstaple it ever. So, right, like ever. Um, that is the completion of the wills process is stapling it together. If you need to make photocopies of it, you're not going to undo the staple. You're not going to carefully take out the staple and remove it. The staple is permanent and it needs to stay permanent. The process of taking out the staple can void the will. The other thing to keep in mind is that copies are not valid. The original will is what needs to be presented to the court, which means that you want to be sure that you keep it in a safe place. So what are some safe places that you can consider? Safety deposit box. I get asked about whether or not to put it into a safety deposit box. You can. That's a safe place, obviously. But keep this in mind. In order to access a safety deposit box after a person has passed away, the person must be an account holder. They must be on the account, and they must have a key to the box itself. And so that is the only way that they can get access to the safety deposit box without a court order. Otherwise, a court order is required for the bank to open up the safety deposit box. So just kind of keep that in mind. I've heard things about like, oh, should I put it into, into my freezer or things like that? I don't know. I'm not a big fan of putting anything in any place where moisture is a possibility and damage can happen to it. Generally, my recommendation is that unless you're going to actually put it into the box, that just keep it in where you keep all your important documents. Where are your birth certificates? Where are your passports? Keep it there. And that's, and then that way it's easy to find, you know where to locate them, and your executor will know where to locate them because that's where all the documents are going to be. You're going to also provide instructions to your executor. You're going to let them know where it's located. You're going to remind them that they cannot undo the staple. Again, did I say it before? That don't remove that staple. And that they need to go talk to an attorney afterwards. They need to go find out what the next steps are. They're going to need to go have a consultation for the attorney to be able to look at the property, what does the will say, what the debts are, and then advise the client, which will be the executor at that point in time, what to do. Do we need to file a probate? Maybe we don't. If we do need to file a probate, what are the next steps are going to be after that to take care of what needs to be taken care of? And then, of course, do the work to actually do the work of transferring the property over to, according to the terms of the will. They must consult an attorney. You cannot represent, an estate cannot represent itself in probate court because an estate is an entity, it's not a person. Or you can only people can represent themselves. So an attorney is required to go through the probate court process. So the executor does need to go talk to somebody. There are certain exceptions, but they are small and they are specific, and very few people actually qualify for those exceptions. So best thing to do, talk to an attorney to be sure that everything's okay. I did forget to put something on here, but I do want to make sure everyone is aware that once you are done and you staple and everything, you can't do anything else to the will. You can't come back afterwards and write something in, right? Like you can't you can't cross out Susie's name and add Bob. If you're going to start crossing things out when you're writing the draft, you're going to do a new one. You don't want to have any stuff like anything like that because that puts into question on whether or not the will is still valid. Because crossing it out and writing over things in the will and things like that is an act of destruction. It is can be viewed as a voiding of the will. So you don't want to do anything along that lines. You want to be sure that once it's stapled and you're done, that it stays the same. The other question that I sometimes get about safekeeping of the will is, do you have to file it? Do you have to send it somewhere, mail it to yourself or something like that? No, that's not required in the state of Texas. You do not have to file it unless you want to. You can file the will with the county clerk's office of where you are a resident. So if you're in Harris County, you would send it to the county clerk here in Harris County, and they will record it and they will send you back the original. And that's one of the exceptions for a copy. It's private. That will is not, you can't search for it or anything on that lines unless and until it's needed. And so, but it is a way of safeguarding the will as well. But again, not required to do so, but you can if you wish. All right. We are now going to move over to a transfer on death deed and filling out this form. Um, I am going to now warn you right now that the transfer on death deed form, the pro se form, the one that you complete yourself, can be a little bit confusing. So bear with me as I kind of go through and explain it. And please ask questions in the chat if you have them as I'm explaining things. So what is a transfer on death deed? It's also commonly known as a TOD for short. It's a way to transfer real property, that's your land and house, to someone when the homeowner dies. It avoids the probate process. If you don't have a transfer on death deed, the will control. As I mentioned earlier, a TOD takes priority over a will. Does not matter when it was executed in timeline to the will. If a TOD's in place, it's going to control. So if you want to change your mind on who gets the house and a TOD has been filed, then you need to either revoke it or do a new TOD in order to change that. But you still own the property. The heir doesn't actually own anything. They don't even have an interest in it. They can't get out a loan on it. They can't do anything with it. So you can manage the mortgage. You can do the repairs, pay the rent, sell it, do whatever you want with it. It's still your property, and you can do what you need to do. It's only the portion of the property that you own. So if you are in community property, you're a joint owner, or the property, then the portion that you own, the 50% that you own, is what you are able to convey in your transfer on death deed. If you inherited the property, you're one of 3 children, and you own a third of the property that you inherited from your parent, you can only convey the third of the interest that you own in the property via the transfer on death deed. You can only ever transfer what you actually own. Okay. And again, property inherited is subject to debt. That includes under a transfer on debt deed. So just because you filed the TOD doesn't mean that the mortgage goes away. Doesn't mean that the reverse mortgage goes away. The financial institution can still foreclose on the property even though it has been transferred under the TOD. And so whoever your heirs are, they need to be aware that that debt exists and that they either need to make uh, steps to obtain financing to pay off the debt or to sell the home if that's what they wish to do so with the property. Right. So the transfer on death deed toolkit is prepared by the Texas Access to Justice Commission, and that is available on the website of texaslawhelp.org, where it's the fill in the blank form. And this one can be fill in the blank, so don't worry about that one. This one is not the will is the one that has the special requirements, but of course it's easier if you type it in. It's just always easier. There's also an online form available at that website where you can where you type in the information and then it prints it out afterwards in a completed format. We are going to be using the toolkit that's prepared by the Texas Access to Justice Commission in this conversation. But just be aware that all of the tips and things I talk about, what's required to be in the document, will be the same regardless of which type of template that you use. Okay. All right, so the first part is going to be naming who is the owner of the property, and everyone must be included. So even though you're transferring your interest in the property, you still need to include your co-owners. You need to include your spouse or your siblings or whoever it is that owns the property with you. So you're going to write your name and the mailing address of the individuals who own that. For everything that is on this form, if there's not enough room on the page, you're going to add another page. You're just going to add another page if you need to. Now, the legal description of the property. This is the one that is actually probably the most difficult part, other than the confusing language a little bit later that I'm going to explain. But this is the most difficult part of it. The legal description of the property is not your mailing address. If only it was as simple as 234 West Elm Street, right? It is not. It is the description that is on your deed. That's going to be where you see that the meets and bounds, the Lot B, Section 3 type of description. Some of them can be short, some of them can be paragraphs long. And so that is where that's the most complicated thing. You're going to want to go find a copy of your existing deed, the one that when you purchased the home. If you purchased it or when you inherited the home, hopefully there was an inherited deed. But if there is not a gift deed that conveys that, you're going to go find the original deed for the home when it was by the original homeowner. So go find that. Well, you're going to clear title, but you're going to go find that legal description. And that's what you're going to type into this box. If that's not enough room, then again, you're just going to add a separate page that says that is like, see the page attached with your legal description on the property. And also just be aware that the property tax statement is also not going to be a complete description. Sometimes it is, sometimes it's the description in the deed is short enough that it does match what's on your property tax statement. But again, sometimes they're just like paragraphs long, and what's on your property tax statement is just a shortened version of it for their own internal purposes. So don't use that. Although if you don't have a copy of your deed and you need to go search for it on the Harris County Clerk's website, then that can be a useful place to start to help find it. And then number 3 is address of the property, if any. That's going to be that physical address. That's going to be the 234 West Elm Street address that you're going to write there. And you're going to include the county as well. All right, there are 3 sections. This is where it's going to start getting confusing. So we're going to go through it slowly. There are 3 sections in a transfer on death deed in the toolkit. There's a section A, a section B, and a section C. Okay. You're going to be picking one of those first ones, one of those big ones, the A, the B, or the C. You're going to pick one. All right. So A is when both properties own the both spouses own the property, and you want to leave it to the surviving spouse. So the primary beneficiary is going to be your spouse, and then your alternate beneficiaries is when both spouses have passed are going to be what's listed there, right? Your children or grandchildren, whoever it's going to be, right? If there's more than one person listed, they're going to be inheriting it equally. So there's 2 people, 50%. You're going to add a third person, 1/3 each. That's what it's going to be. And so that is what section A is, right? Goes to my surviving spouse. If both of us have passed, then to the alternate. It's going to go to my surviving spouse. When my surviving spouse passes, it's going to go to the alternates. So that's what section A is saying, that the ultimate owner of the property is going to be the alternate beneficiaries. Okay, so that's what section A is doing. And now we're still in that 3 sections. We're picking one. For section B, only one spouse owns the property. So section A is it's community property or joint held property, right? Like it's community property. So section B is that the person owned the property prior to marriage, or it was made into separate property after marriage. Whatever reason, there's only one owner of the property, but they're married. And now they want their spouse to inherit the property. So they're going to name the spouse as the person who inherits the property. And then the alternate beneficiary is only if the spouse has passed away. That's really important. That's the difference between A and B here. A, the ultimate person who's going to inherit the property is the alternate, the final beneficiary. They will be the final owners of the property under A. Under B, if the spouse survives, they are the final owner of the property. And when they pass, the house will pass according to whatever they do, their transfer on death deed, their will, etc. Right? So, or if they have no will, intestate laws. That is what this is saying, right? If you pick your spouse as the first beneficiary, they will be the final owner of the property if they survive. And the alternate beneficiaries for this one only comes into effect if the spouse predeceases the owner. So if you're married, you own your house as a single person, it has separate property, it's your separate property, your spouse passes before you, then the transfer on death deed is going to go to the alternates that are listed. If you pass first, it's going to go to your spouse, and then your alternates will not inherit this property at all, according to this document. Okay. And again, if more than one person is listed, it's going to be equally shared when it gets to the alternate level. Okay. All right. All right. So now for both A and B, we have what can get a little bit complicated, right? Which is what happens after the alternate beneficiary. So now we've gotten to the alternate beneficiary, but they have passed. And now who's going to get the property after that? That's really what we're talking about here, right? If your alternate beneficiary is a child or a sibling, you must complete this section. Okay. And so, I'm sorry, I spoke that. So, but you should complete the section in general, right? So if it's your child or sibling, you're going to pick A, which means that if you pick A, that means it's going to go to that alternate's heir, right? Though it's going to go to their children. Or their grandchildren, whatever, right? Whatever descendants that they have. So that's going to be the A. If they're your child or a sibling, that's what you're picking. If you pick B, it's not going to. It's going to go to the other alternate beneficiary. So again, so you have two. You have Bob and Susie, right? Bob has passed. If you pick A, Bob's children inherits his portion of the estate of the house. But if you pick B and Bob has passed, it's going to go to 100% to Susie. So that's what will happen if you pick B. But if both Bob and Susie have passed, then the transfer on death deed is void. No one inherits. It's going to go pass according to the will because now there's no effective Todd. So now the will is going to control, and it's going to be whatever your alternate beneficiary is according to your will. So that is what the difference is between the two of those. And you're going to complete this for if you pick the big section A and B. Okay. All right. Hope everyone's still with me. Okay. All right. Now we're back to that big ABC section that, we're going to pick one. We're going to pick an A, we're going to pick a B, or we're going to pick a C. Now we're getting to C. This is everybody else. A spouse is not involved as a primary beneficiary. Now, a spouse may be a beneficiary, but not the primary one. They're not going to be the first person who may get it. So that's what but it's pretty much everyone else is going to be listed here that has the beneficiary. So you're going to list has your primary beneficiary, whoever that is, your siblings, your kids, your neighbor, like whoever, right? Not your pet. Don't give it to your pet. So that's what you're going to list, and then you're going to list alternate beneficiaries as well on that. Okay. And now, just so that everyone's kind of clear on this, right? Like the alternate beneficiaries only take if the primary beneficiaries have passed. Like they only come into effect when there is no primary beneficiary who survived. Okay. All right, so yeah, I had a little animation there. All right, now you have a second set of A, B, and C. All right, so remember we had that big one, A, B, C, the big categories that we have. You're going to pick one of those. If you pick C, under C, there's another A, B, C. You need to complete all of them, okay? Because this is what's going to happen when you have one primary beneficiary passes away. What happens if no primary beneficiary survives? And then what happens if an alternate beneficiary doesn't survive? So it's all of these contingencies of we're planning for, we don't know what's going to happen, so we got to plan for each different thing. So that's what the difference is. So remember, if you're doing C, you must do this A, B, and C under that big C. Okay. All right, so section A, one primary beneficiary survives me. So again, we got Bob and Susie who are our primary beneficiary, and they are inheriting the property. So what happens if one of them has passed away and one has survived? A is saying, I want that portion to go to that person who's passed to their heir. So Bob has passed, it's going to pass to his children. Okay. And then B is no, I don't want it to go to Bob's children. Susie will inherit 100% of the property. It doesn't go to anyone else. So that's the effect of that. Okay. So B is if no primary beneficiary survives me. Both Bob and Susie have sadly passed before me. And so now who I want to get? A, their heirs. Bob's children will get his 50%. Susie's children will get her 50%. That is where B comes into play. Now, B under B, I'm so sorry for these letters. It's the alternate beneficiary. So now you have your two primaries. You're going to say, I wanted to go to their heirs. But if you're like, nope, if they don't survive me, I don't want their heirs to get it. I wanted to go to who I named as my alternate beneficiaries, right? So let's go back up. So as you can see, I don't know if you can see my mouse, but like right here, you'll see the alternate beneficiary. So when these two have passed, it goes to these alternate beneficiaries. Okay, so that's what section B is doing here. And then under section C is when we're talking about alternate beneficiaries. So again, we're kind of these contingencies. One, only one primary beneficiary has passed away. Two, both primary beneficiaries have passed away. And now three, now an alternate, right, has passed away. And where do we want it to go at that point in time? Alternate, their heirs. It will go, their portions will go to their heirs, or B, no one else. Now the Todd is null and void. Now the property is going to pass according to the will. Okay. All right. So what to do next with the Todd? You're going to sign it with a notary present. No witnesses are required. It's just a notary. They will sign and affix it. You must record the will. Recording is filing it. You must send it into the county where the property is located. If you're in Harris County, it's in Harris County. And in order for it to be valid, it is not valid if you do not file it. So just be aware of that in order for it to be effective, you must file it. Once recorded, the clerk will return the Todd to you. You're going to keep it in a safe space along with your will and other advanced planning documents that you have. So lastly, in the next couple of minutes, we're going to talk about planning for incapacity. I'm going to spend very little time on this because the good news is that these forms are standard. So when we're talking about planning for incapacity, these are what are known as statutory forms, or the majority of them are, or they're really pretty basic forms. And so when you pull them up, what that means is that the folks in Austin have already written it for us. So we don't have to write anything. So, and again, you'll get the templates as part of the email, so you can take a look at that. And they're standard language, and it's just deciding how you want to complete it, right? You would just be going in and saying, this is who the powers I want them to have, who my alternate is going to be, and this is the decisions that I want to have. So if you want to learn more about what each document does and how to make those decisions, I do recommend that you attend and watch my other presentation on advanced legal planning, because that is where I spend a lot of time talking about what each document does and how to think about planning and executing those documents. But you don't have to draft anything. It's just basically which box are you going to check, and then that type of thing when it comes to completing these forms. And these forms are going to be your statutory durable power of attorney, your medical power of attorney, an advanced directive, which is in the life decision making, also known as a living will, a declaration for mental health treatment. That is a document for individuals who are at risk for psychiatric hospitalization. So that's not something that everybody needs, but if that's something that happens to you, it's a really important document to have in effect. Then there's a declaration for a guardian in the event of later incapacity, a HIPAA release to allow hospitals and other people who are subject to HIPAA to be able to share medical information when they need to, and a document known as supported decision making. And so again, watch the other presentation to learn more about that. But all of these documents are available on texaslawhelp.org, and we will send you the templates on how to complete that. And then depending on the type of document, you can either use it with complete it with a notary and or with witnesses. This is a lot of stuff, and I just basically told you about a very simple will, a very simple Todd. Well, no, actually, not simple Todd, but I told you how to complete the Todd. But this can be complicated. If the document is not going to serve your needs, then you may want to, then you should consider counsel. You should look for somebody who can write a will that can meet your needs. Eligible clients may be able to receive free services. So even if this document may work for you and you qualify for services, if you apply for services, somebody will help draft all of the documents for you. And then you will know for a fact that if you didn't think of something, like you didn't see around a corner, the attorney will help you see around that corner, and they'll be able to do that for you, and be able to do that. So don't be overwhelmed by the amount of information that you have heard today, and in general. But with that, I'm done. This is probably the first time I've ever finished a presentation before 3 o'clock. But if you have any questions, feel free to unmute yourself or put them into the chat. Happy to answer them in the time that we have remaining. If you are watching this online on Facebook or another streaming site, please be careful not to put anything personal in the questions. It is on the internet. Everyone can see it. And plus, I cannot provide specific legal advice today. But for those of you, because the cartoon is a little blurry depending on how you're watching it, it's Mr. Turkey who's in his attorney's office, and it says, "With Thanksgiving around the corner, I thought this would be a good time to review my estate plan." So with that, thank you so much for your attention. And does anyone have any questions?
All righty. I'm checking social media here to make sure I'm not missing anything. But yeah, this is the first time that we've ever completed this presentation in this short amount of time. And just to kind of reiterate what Jesse just said, by no means do we expect you guys to be the legal experts or whatever, following this presentation. So do take this time or take this as an opportunity to go back and review the presentation again. Look over the documents. I will be sending you the link to the sites and the resources that she made reference to throughout the presentation as well, so that you guys can go back and then start creating. Melissa has a question. Would you like to unmute yourself, Melissa?
Yes, thank you so much for taking my question and for presenting this information.
Go right ahead.
Okay, my question is it possible to use the documents that are kind of fill in, as she kind of explained it, as a template to you kind of typing up yours personally, just to make sure you've covered all of those basics? And if you do that, but you still have some other concerns or other things that you want to make sure that are covered in your estate plan that maybe was not covered in that specific paperwork, could you take what you've already created to an attorney, and then they can just kind of add to that? Or is it best to just kind of let them do the entire process? Hopefully I'm making sense.
You are making sense, and I'm going to kind of answer it in different ways to kind of make it applicable to more people. So the answer is yes, and in fact, I've actually have advised that to some individuals where what they needed to do that was a deviation that was different from the template was very minor. It was a very small thing, and it was really easy for them to write it themselves. And it's like, well, just take the template and type it up and match the language that's generally in there, and then follow the instructions needed for an attested will, right? The two witnesses and all that kind of and that kind of thing. So yes. So to answer that particular question, yes, you can. I would be weary if it becomes more complicated than that. Because once you get to a stage where you feel like I need an attorney to confirm that what I've written is done correctly, then generally most attorneys like to draft their own documents. And so it's pretty rare for you to go look at an attorney and be like, hey, can you just confirm that what I did was correct? Because typically they will want to go ahead and just draft it. If it starts getting complicated enough that really it requires them to kind of evaluate it and make a decision that the paragraph is good, they're just going to want to write it themselves. And so I would say that it really kind of depends on the complexities of what it is that you're trying to add. If it really is something as simple as, basically saying that, I have $20,000 in a bank account. I want the first 5,000 of it to go to Susie who replaced my roof, and then the remainder 15 to be divided equally among Bob, Susie, and Joanna. Then, that's a simple statement. Like there's not a whole, like that's an easy thing to write in under a specific bequest that, you may not need an attorney to want to look at it. But if you're talking about like a life estate where you're like, I really want my child to live in the house until, something along that lines, you're probably going to want the attorney to draft that from the get-go.
Did that answer your question, Melissa?
Yes, it did. Thank you so much. I appreciate that.
Okay. I don't see any other question here in the chat. And Miss Quantera, I see you turned your camera on. Did you have a particular question today or no? Or
No.
and I'm glad you're not driving today.
Yes.
She tunes in when she's in the car. So it makes me nervous to see her driving and then, trying to listen in and pay attention at the same time. So, but again, this presentation, along with the presentation that Jessie did last month about estate plans or legal advance planning and why you actually need it, when she goes into a little bit more detail about the other documents that make up an estate plan, I will be including that recording for you all to go back and to watch, along with the copies of those templates that she makes reference to as well, so that you can then kind of create your own from there as well. And then the link for the online resources that she spoke of will be included there too. And now with the families and with the holidays and everything coming up, this will be the perfect opportunity for you guys to kind of bring up and have conversations, since the families are all sitting around, just in general. It doesn't have to become a dreaded kind of deathly conversation or anything like that, but just kind of in passing, hey, I was on this workshop or whatever, and I got my documents done. You guys have your documents, or do you have blah, blah, blah? You know what I mean? Just kind of make mention of it so people can kind of start thinking about stuff like that, and knowing that it's important to have those kinds of conversations and dialogues to make sure everybody's on the same page. We have heard over the last 7, 8 years that we've been doing this, oh yeah, my family, we all get along, we don't have any of those problems, and all this kinds of stuff. But the very moment that someone passes away or what have you, that's when the real grief kicks in, and then grief takes over, and you just never know how somebody's going to respond and go through that grieving process. So, they tend to take it out on the folks that are most closest to them, and you just never know how they're going to react. So, well, so it's better to have that kind of to try to alleviate as much of that kind of a conflict or whatever as you possibly can well in advance. So, again, just start having the conversations now that the family's going to be gathering around or whatnot. Or if pop the presentation in or whatever and have them look at it while you're all are sitting there, and that'd be even better too, to, have just sit around the TV and just listen or have the conversation about it. You know what I'm saying? So, that would be ideal. Let me see. I'm trying to go through all the social media pages at the same time to make sure that I'm not missing anybody or missing any comments or anything like that. Before you go, Jessie, since we have a little bit of time left, and I don't see anything as of yet. I guess you're just getting so good, Jessie, that people, they don't have questions. You're so thorough and so detailed.
Well, I'm so glad to hear that. I always worry about the Todd because it gets so confusing with all the same ABCs. So, but I'm glad.
And
But of course, everyone can just watch the recording if you have any questions afterwards, and you can always come back, like come back to another presentation after you start trying to draft these documents yourself, and then you're like, well, I have more questions. Again, remember, I can never answer anything specific. If you would like me to actually review documents or help draft documents, you do have to apply for services. But when you're doing it, as long as you can ask it kind of in that really broad, general way, I should be able to answer it in another session. So,
okay.
okay.
All right. With that being
Thanks so
said,
much. Happy Thanksgiving for anyone who's going to be celebrating Thanksgiving holidays, and happy Veterans Day to all of our veterans and out there. And my husband's a Marine, so I always have to say happy birthday to the Marines because that is coming up
what
too.
is the hoorah, or what is it? All right, thank you guys very much for joining us this afternoon. Again, a link of this recording of the presentation, the link for the recording of last month's presentation with more of the details and along with those templates will be forwarded to all of you all so that you can potentially draft your own documents and kind of get some things established and put in place. We hope that the information that you all heard here today has been helpful. And we ask again that you share it and pass it along to as many people as you possibly can so that they can become conscious of the fact that these are the kind of things that need to be put in place and need to be done in order to preserve those assets and to make sure that your family is good. The one thing that you don't want to do is to leave your family in a process when they are trying to grieve and handle all of your affairs at the same time that did not get done prior to. That is the most stressful thing ever. And let me just give testimony real quick to that, because Jess and I were just kind of talking about it's been 4 years and it's time for me to wrap up my dad's probate thing. But the beginning process of that and trying to get everything together at the same time, right after he passed, right during COVID, it was a mess. It was an absolute mess trying to figure out safety deposit box locations, and the bank moved. I had a key and had no bank to go to, didn't know where I was going, and I had to call on Jesse. Jesse, what do I do? help me out here. Give me some guidance, some kind of direction. And so she was a godsend to help me through that little time, that moment. So I wholeheartedly appreciate it. I wholeheartedly encourage you guys to reach out and apply for services. Do not automatically discount yourself and automatically assume that you will not qualify, because there are services and resources that are out there that can assist. If you cannot qualify, they will give you some guidance in some other direction too. You know what I'm saying? So don't think that you're out there by yourself. So with that being said, you all have a wonderful holiday. We hope to see you throughout the month and next month for all of our other presentations for the remainder of the year. There is a link that will pop up on your screen that we ask that you to just complete the survey. We'd love to hear from you guys to see, just kind of tell us what'd you think? What do you want more of? What do you want less of? Are there presentations or topics that are out there that we have not addressed that you guys may be interested in? That we're looking for your feedback as we are in the planning phases for the 2025. It was 2025 already. Gosh, 2025 year already. So we can try to figure out what topics and plan our schedules and things like that accordingly. So we'd love to hear from you guys. You all have a wonderful remainder of your day. You take care of yourselves. You stay safe. Jesse, thank you again. Thank you for all of our participants, and we will see you all again another time. All right. Bye-bye, Miss Quintero. Thank you, Miss Melissa, Miss Pat.